The first crossing. October 6, 2025, 9:30 a.m. Imagine, if you will, walking through the security checkpoint of the Abbotsford Law Courts on a crisp October morning. The metal detectors chirp softly. The sheriffs nod with professional courtesy. You take the elevator to the second floor, where courtroom 201 sits among a corridor of identical doors, each one a portal to someone's unfolding legal drama. Inside courtroom 201, the air carries that peculiar scent of old wood and industrial cleaner. The judge's bench looms high, intentionally so, a physical manifestation of judicial authority. Below it, two tables face forward like students' desks before a teacher. To the left, the Crown prosecutor sits, representing the state and its interests. To the right, the defense, representing the individual against that awesome power. This is where Kevin Lester's journey through the criminal justice system truly begins. The hearing is designated FASBD, first appearance scheduled by default. Let us pause here because these seemingly bureaucratic letters tell a story. When charges are laid in British Columbia, the system doesn't wait for lawyers to negotiate a convenient date. The machinery activates automatically. Like a train departing the station at its scheduled time, the first appearance is set by default, meaning the court computer system, following its programming and rules, has allocated this time slot, this courtroom, this judge, for this particular defendant. Why does this matter? Because it reflects a fundamental philosophy: justice delayed is justice denied. The system cannot afford to wait for perfection or convenience. It must move. And so Kevin Lester, whether ready or not, whether fully understanding the gravity of his situation or not, must appear. During a first appearance, something profound occurs that most people in the gallery might miss. The defendant stands, usually nervous, perhaps defiant, perhaps confused, and the charges are read aloud. Not summarized, not paraphrased. Read with legal precision. This is the moment when the abstract accusations become concrete. The Crown is saying, "We, the people of British Columbia, believe you committed these specific acts in violation of these specific laws." The defendant might enter a plea, though many reserve this right for later. Legal representation is confirmed or arranged. If there are bail conditions, restrictions on where one can go, whom one can contact, what one can possess, these are reviewed and understood. The hearing is brief, perhaps 10 or 15 minutes, but it is consequential. It sets everything in motion. Notice that the record shows two entries for this date, entries labeled 1 and 2. This doubling appears throughout Kevin Lester's file like a recurring motif in a symphony. Each court date, 2 entries. The most likely explanation is that Kevin faces 2 separate charges or counts being processed in tandem. Imagine 2 threads being woven simultaneously through the same loom. Different charges, perhaps, or the same charge applied to different instances, but linked by the same case number, the same defendant, the same journey. 2. The conference. November 3, 2025, 9:30 a.m. Time moves differently in the justice system than in ordinary life. 4 weeks have passed since that first October morning. In the world outside the courthouse, Halloween has come and gone. Children have traded their candy, leaves have fallen, the days have grown shorter. But inside the legal machinery, this interval is purposeful, a deliberate pause built into the system's rhythm. Kevin Lester returns to courtroom 201, same building, same floor, same time slot. But today's hearing carries a different designation, CLCSBD, Case, Crown, Court Conference scheduled by default. To understand this, we must understand a fundamental truth about criminal proceedings. They are negotiations as much as they are confrontations. The Crown prosecutor and the defense lawyer are adversaries, yes, but they are also professionals operating within the same system, bound by the same rules, seeking, in theory, the same ultimate goal, a just outcome. The case conference is where this negotiation begins in earnest. Picture the scene. In the hours or days before this court date, disclosure has been exchanged. Disclosure is the legal term for evidence. Police reports, witness statements, photographs, forensic results. In Canada, the Crown must share virtually all of its evidence with the defense. This isn't generosity, it's constitutional law. The Supreme Court of Canada has ruled that an accused person cannot defend themselves against accusations they don't fully understand. Justice, the court has said, requires transparency. So by November 3rd, defense counsel has reviewed this evidence. They have met with Kevin Lester, perhaps multiple times, in the gray visiting rooms of the courthouse or in the cramped privacy of a law office. They have explained what the Crown has, what it means, what the possible outcomes might be. They have discussed strategy. Now, in the case conference, lawyers for both sides stand before the judge. The conversation might sound like this. Your Honor, we've reviewed disclosure and would like to discuss potential resolution. Or perhaps, Your Honor, there are some disclosure issues we need to address before we can proceed. Or even, Your Honor, my client maintains their innocence. We'll need to set this matter for trial. The judge listens, makes notes, asks questions. What is the Crown seeking? What is the defense offering? Is there common ground? The judge doesn't decide the case at this moment. That's not the purpose, but rather ensures both sides are communicating, progressing, honoring their obligations to the court and to justice. The SBD designation, scheduled by default, reminds us again that this is not optional. The system requires this checkpoint. Like a pilot's pre-flight checklist, certain steps must be completed before the larger journey can continue. Three. Preparing for judgment. November 24, 2025, 9 a.m. Notice the shift in time, 9 a.m. instead of 9:30 a.m. 3 weeks later, in the corridor leading to courtroom 201, Kevin Lester returns. The time has shifted, 9 a.m. now, rather than 9:30. This might seem trivial, but in the choreography of court scheduling it matters. Different time blocks often correspond to different types of proceedings. The 9 o'clock slot might be reserved for lengthier matters, or for cases that need to be heard before the day's main docket begins. Today's designation is PARSBD, pre-arraignment scheduled by default. Arraignment. The word itself carries weight, derived from Old French, meaning to call to account. In Canadian criminal procedure, arraignment is the formal process where the accused is called before the court and asked to enter their plea, guilty or not guilty. It is a threshold moment, a point of no return in many ways. But we are not at the arraignment yet. This is pre-arraignment, the preparatory stage. Think of it as the final equipment check before a mountain climber begins their ascent. All the pieces must be in place. Disclosure must be complete. Any constitutional issues must be identified. The defense must have had adequate time to prepare. The accused must understand their options. In this hearing, the court essentially asks, are we ready? Has the Crown fulfilled its disclosure obligations? Has the defense had sufficient time to review everything and advise their client? Are there any preliminary motions that need to be addressed? Challenges to the admissibility of evidence? Questions about whether the accused constitutional rights were violated during arrest or investigation? This is also the stage where the reality of the situation often crystallizes for defendants. The initial shock of the first appearance has faded. The abstract discussion of the case conference has become concrete. Now, facing pre-arraignment, Kevin Lester must confront a stark choice. Will I plead guilty and accept responsibility, hoping for a negotiated sentence? Or will I plead not guilty and demand that the Crown prove every element of their case beyond a reasonable doubt? The pre-arraignment doesn't force this decision immediately, but it makes clear that the decision is imminent. The machinery is moving inexorably forward. Soon, there will be no more postponements, no more conferences. Soon, there will only be judgment. For the disposition question. December 15, 2025, 9 a.m. We enter the winter portion of this journey. It is mid-December now. Outside the courthouse, Christmas lights adorn the streets of Abbotsford. Inside courtroom 201, at 9 o'clock in the morning, Kevin Lester's case takes a significant turn. The hearing is designated FXDSBD, Fixed Disposition Scheduled by Default. Disposition is a deceptively simple word. In legal parlance, it means the final resolution of a case, the outcome, the conclusion, the answer to the question, what happens now? But fixed disposition suggests something more specific. The court is attempting to establish or set a path toward resolution. This is where we must read between the lines of the court record, like archaeologists interpreting ancient fragments. There are two primary paths a criminal case can take. The first is trial. The Crown and defense present evidence before a judge or jury, witnesses testify, lawyers argue, and the trier of fact decides guilt or innocence. Trials are adversarial, unpredictable, resource-intensive. They are the exception, not the rule. In Canada, as in most common law jurisdictions, the vast majority of criminal cases, estimated at 85–90%, resolve without trial. The second path is resolution through plea. The accused pleads guilty, often to reduced or amended charges, and the focus shifts from whether they committed the offense to what the appropriate punishment should be. The appearance of fixed disposition in Kevin Lester's record suggests movement toward the second path. Something is being negotiated. Perhaps the Crown has offered to reduce charges in exchange for a guilty plea. Perhaps there are discussions about joint sentencing recommendations, where both Crown and defense agree on what sentence they'll propose to the judge. Perhaps there are considerations of alternative measures, conditional sentences, probation, community service. But here's what's crucial. The judge cannot simply rubber stamp whatever the lawyers agree to. In Canadian law, the judge retains the ultimate authority to reject any plea bargain that doesn't serve justice. So when the court fixes disposition, it's not just the lawyers agreeing. It's the judge evaluating whether the proposed resolution is appropriate given the nature of the offense, the circumstances of the accused, and the interests of society. The 3-week gap between pre-arraignment and this fixed disposition hearing was necessary time. Time for negotiations. Time for the defense to obtain a pre-sentence report if needed, a detailed assessment of the accused background, circumstances, and likelihood of rehabilitation. Time for the accused to complete anger management programs, addiction counseling, or other rehabilitative measures that might influence sentencing. Time for both sides to research comparable cases and sentencing precedents. Yet even now, as we'll see, the matter doesn't conclude. The record shows Kevin Lester will return to court again and again. But what complication has arisen? 5. The extended negotiation. January 12, 2026, 9 a.m. The calendar has turned to a new year. Nearly a month has passed. The holidays, Christmas, New Year's, have come and gone. For most people, this is a time of celebration and renewal. For Kevin Lester, it is a time of waiting, of uncertainty, of a future still undecided. He returns to courtroom 201, same time, same place. But the designation has changed subtly. FXDSBS, Fixed Disposition Scheduled by Status. That final letter change from D, by default, to THIS, by status, tells a story. This hearing wasn't automatically scheduled by the system's standard timeline. Instead, it was scheduled based on the status of the case, meaning something specific triggered the need for this appearance. What might have happened? Several scenarios are plausible. Perhaps the pre-sentence report wasn't ready by December 15th, and the court needed additional time for its completion. These reports are thorough. Probation officers interview the accused, contact family members, review employment history, assess risk of reoffending. They can't be rushed. Perhaps there were issues with restitution. If Kevin's alleged offenses involved financial loss to victims, the exact amount must be calculated, verified, negotiated. Perhaps the Crown and defense couldn't reach agreement on sentencing, and the court gave them more time to find common ground. Perhaps Kevin Lester himself needed more time to complete a treatment program, to gather character references, to demonstrate through his actions during the pre-sentencing period that he deserves consideration. Or perhaps, and this is darker but possible, there were compliance issues. If Kevin was released on bail conditions, and those conditions were violated, the court might need to address that before proceeding with sentencing. The record doesn't tell us which scenario is true, but what it does tell us is that the machinery, which had been moving steadily forward, has hit some form of complication. Not a complete breakdown. The case is still progressing, still active, but a snag in the gears that requires attention and patience. This is the reality of the justice system that television doesn't show. It's not dramatic confrontations in every scene. It's waiting. It's paperwork. It's small procedural hurdles that seem trivial but matter immensely to the people involved. The 6. The continuation. February 2nd, 2026, 9 a.m. We arrive at the present day. 3 more weeks have elapsed. It is now February 2nd, 2026, today, at the time of this examination. Kevin Lester stands once again in courtroom 201 at 9 o'clock in the morning for another hearing designated FXDSBD, back to the by default scheduling. The return to by default from by status suggests that whatever issue delayed proceedings in January has been addressed, and the case has returned to its normal procedural track. The machinery has overcome the snag and resumed its steady movement. By now, Kevin Lester has become familiar with this routine. The walk to the courthouse, perhaps from a bus stop or parking lot. The security checkpoint. The elevator. The hallway with its fluorescent lights and vinyl floors. The courtroom with its particular acoustics, the way voices echo slightly off the wood paneling. The judge's expression, professional, neutral, focused. But familiarity does not equal comfort. Each appearance carries consequence. Each time the file is opened, examined, discussed, Kevin's future hangs in the balance. What we can deduce from this continued series of fixed disposition hearings is that the resolution is complex. Simple matters, a single charge with clear facts and an agreed sentence, resolve quickly. But Kevin's case, with its 2 parallel tracks, remember those duplicate entries, has required multiple court dates focused specifically on disposition. This suggests either the charges are serious enough that appropriate sentencing requires careful deliberation. The circumstances are complex, perhaps involving multiple victims or sophisticated fact patterns. There are mitigating factors that the defense is working hard to emphasize: mental health issues, addiction, difficult life circumstances that might warrant leniency but require substantial documentation. Or there are aggravating factors that the Crown insists must be reflected in the sentence: prior criminal history, breach of trust, harm to vulnerable victims. Act 7. The anticipated conclusion. February 11th, 2026, 9:30 a.m. The future approaches, 9 days from now. The record shows one final scheduled appearance, set for February 11th, 2026, at 9:30 a.m. But notice 2 significant changes. First, the courtroom has shifted from 201 to 204. After maintaining the same courtroom for 6 consecutive appearances spanning 4 months, Kevin Lester's case is being heard in a different space. Second, and more importantly, the designation has changed to HR, anticipated hearing. Let us unpack the significance of this layer by layer. In court scheduling, different courtrooms often serve different functions. Some courtrooms are designated for routine appearances, the administrative work of justice, the conferences and status updates. Other courtrooms are reserved for substantive proceedings, trials, sentencing hearings, major motions. Courtroom 204 may be larger, or configured differently, or assigned to a judge with specific expertise or seniority. The term anticipated hearing is particularly revealing. Unlike the previous appearances, conferences, prearraignments, disposition discussions, this is designated as a hearing. Not a meeting, not a check-in, a hearing. What does this mean? In legal parlance, a hearing is a proceeding where evidence may be presented, arguments may be made, and judicial decisions may be rendered. The word anticipated suggests that everyone involved, Crown, defense, court staff, expect something substantive to occur. They have marked this date with particular importance. Given the progression we've traced, two scenarios seem most likely. Scenario 1. Sentencing hearing. The disposition has been fixed, meaning the Crown and defense have reached an agreement, or the accused has entered a guilty plea, and now the court will hear submissions about the appropriate sentence. In a sentencing hearing, the Crown outlines the aggravating factors, the seriousness of the offense, its impact on victims, any relevant criminal history. The defense presents mitigating factors, the accused remorse, steps taken toward rehabilitation, personal circumstances that help explain, if not excuse, the conduct. Character witnesses might testify. Victim impact statements might be read. And finally, the judge will deliberate and pronounce sentence. This could take several hours. Hence the need for a dedicated courtroom and a time slot designated as a hearing rather than a routine appearance. Scenario 2. Preliminary hearing or trial preparation. Though less likely given the repeated, fixed disposition designations, it's possible that resolution efforts have failed and the matter is now proceeding toward trial. In this case, the anticipated hearing might be a preliminary hearing to determine if there's sufficient evidence to proceed to trial, or it might be a pretrial conference where procedural matters are addressed before trial begins. The first scenario seems more probable. After months of disposition discussions, the February 11th hearing represents what lawyers call D-Day, Decision Day, or perhaps more aptly, Disposition Day. Epilogue. The pattern revealed. We pull back now, returning to the wide view we began with. Let us step back and look at the complete timeline we've traced. October 6th, first appearance. November 3rd, case conference. November 24th, pre-arraignment. December 15th, fixed disposition. January 12th, fixed disposition by status. February 2nd, fixed disposition. February 11th, anticipated hearing. This is the anatomy of a criminal case. Not a violent confrontation in the courtroom. Not dramatic confessions or surprise witnesses. But a slow, methodical, bureaucratic process where lawyers negotiate, judges supervise, and the accused waits. The duplicate entries, those two parallel tracks running through every court date, remain Kevin Lester's constant companions. Two charges, or two aspects of the same case, being processed simultaneously. Like twins being raised side by side, they move through each stage together, inseparable. And that persistent code, 100, appearing after every hearing designation? It's likely an administrative marker, a file category or priority code invisible to the general public but meaningful to court staff. It might indicate the type of offense, or the processing protocol, or the urgency level. It's another reminder that beneath the grand philosophical ideals of justice, there exists a practical reality of spreadsheets and databases and filing systems. Closing reflection. What this reveals. What have we witnessed in Kevin Lester's journey through the Abbotsford law courts? We've seen how justice in a modern democracy actually functions, not through swift judgment, but through patient process. We've seen how the system balances competing interests, the state's duty to hold lawbreakers accountable, and the individual's right to fair treatment and due process. We've seen the role of time in justice. Those weeks between hearings aren't delays. They're necessary pauses for investigation, negotiation, reflection. Justice rushed is often justice denied. We've seen the role of documentation. Every appearance is recorded, time-stamped, categorized. This creates accountability, a permanent record that can be reviewed, analyzed, appealed if necessary. And we've seen the human element lurking behind the bureaucratic codes. Behind FXDSBD and PARSBD and HR is Kevin Marlon Lester, a real person in this fictional narrative, whose life has been disrupted, whose future is uncertain, who must navigate this complex machinery with consequences that will follow him long after the courthouse doors close. On February 11, 2026, when Kevin Lester stands in courtroom 204 at 9:30 in the morning, One chapter of his story will likely end. A new one may begin, whether that involves incarceration, probation, community service, or some other consequence, we don't yet know. But what we do know is that he will have had his day in court. Not 1 day, but 7. Not a rushed judgment, but 4 months of careful deliberation. This is the promise the justice system makes. Not perfection, but process. Not vengeance, but measured consideration of how to balance accountability with rehabilitation, punishment with redemption, society's need for safety with the individual's capacity for change. The machinery of justice grinds slowly. But it grinds. Fade to black. End of Chronicle.